Number 21, Ashland Management. Counsel, got any rebuttal time?
Yes, please. I would like to reserve 3 minutes if it pleases the Court.
Okay, you have it. Go ahead.
Thank you, Judge. The central issue in this case is whether the defendants were prohibited, either by law or by contract, from soliciting business from 44 specific persons who were either clients of the former employer, the plaintiff, or were financial professionals who occasionally referred clients to the plaintiff. Now, plaintiff offers 3 theories in support of its claim that defendants were, in fact, barred from contacting these people. First, the plaintiff claims that defendants obtained the names of these 44 people they contacted after leaving its employ through improper means, specifically by accessing without authorization its Federal Express account. Plaintiff's second claim for why, or second theory why, the defendants were barred from contacting these people is its contention that the names, the identities of these people were trade secrets and therefore its property. Defendant's third claim in support of barring the defendants from contacting these 44 people is that there was a confidentiality agreement in place which the plaintiff has asked the courts throughout this case to deem to be a restrictive covenant barring solicitation of its clients, even though that agreement has no non-solicitation language in it and is also completely lacking.
Does the agreement say anything other than that you must comply with your common law obligations?
The agreement doesn't even say that. It says you can't reveal, divulge, use a list of things, a laundry list of things, records, data.
I mean, as you interpret it, is it essentially just an agreement not to steal?
It's an agreement not to take confidential information. The definition of confidential information is extremely verbose and ambiguous, and the critical thing.
But client names aren't on the list.
They're not on the list, no, Judge.
But I mean, presumably you're not allowed to take your employer's confidential information even if you don't sign an agreement, are you?
But I think that the list of, or the definition of what is confidential information here is extremely ambiguous, and that runs smack into 2 critical concerns in this area, which implicates the policies of fostering competition and not depriving an employee of the ability in the future to earn a living.
Except that in this case it wasn't information or total information that you had readily at hand because they had to go into the employer's FedEx account to get some of the information.
No, with all respect, that's not true. There's no dispute. If there's one thing that's crystal clear in this record and is a completely undisputed fact, is that these defendants knew every one of the 44 persons they solicited.
But it was still convenient to have the list of 44 in case they forgot some?
No, I don't think it was ever a question of their forgetting.
Why did they bother to go in if they know everything?
I think, honestly, it's not in the record, and I'm not sure it's material here, but I think they did it inadvertently. It's something that I've been puzzling about.
Well, maybe they knew the entity, but they didn't know the contact person.
No, it is the contact.
Can't that be the confidential bit of information, who the particular person is in this large firm?
No, Judge.
Who works
On
with
this
the
record,
employer?
it is crystal clear that they knew every one of the 44 people.
But again, then it's inconceivable why they would go in. I mean, they're looking for something, no?
Well, let's assume.
Don't just go in by accident. I mean, that doesn't make any sense.
Well, I think it happened inadvertently, and I can think of.
What does that mean? What does it mean,
I can speculate
inadvertently?
as to how it may have happened. Being a user of Federal Express's online services myself.
Well, whose account was this? This was their account, right? And they were being billed for it?
This, it turned out, was the plaintiff's account.
Right.
Okay. How they got into it, I'm not entirely certain.
But it couldn't a jury find? I mean, I understand. Maybe they used the wrong account. Well, I thought this was my account number. It turns out it's his account number. But couldn't a jury find that they did it on purpose?
The jury could, but I don't think that it affects the outcome.
I mean, is it a jury could find that they did it on purpose to gain something, even if only minor convenience? I mean, maybe they knew all the names, maybe, but maybe they didn't know, they'd forgotten how to spell 3 of the names, they didn't know the zip codes. It's nice to have a nice little list.
Sure. For the purposes of this appeal, I'll concede that a jury could find that the defendants accessed this account deliberately. But it wasn't, I think the critical thing here, the gist of all of the claims that the plaintiff is making and the relief it's seeking is that you are taking my clients. Now, these clients are already known.
Isn't that the question of fact, whether whatever it is readily ascertainable? Isn't that the question here, the very question and issue that,
I think we're talking about two different things. There is personal knowledge of each of these 44 people, and that's clear because the chairman of the company put in an affidavit in opposition in which he said, Jones and Obakowski were introduced to these clients through their employment by Ashland and would not be aware of their investment needs and strategies but for their employment by Ashland. And further, during his deposition, he conceded that, especially in the case of Mr. Jones, who had been with the company for 17 years, that Mr. Jones was the primary contact for these accounts.
Yeah, but isn't all of that at variance with their conduct? And, how do you get beyond that they go into the other person's account to get this information that they already know? Well, and doesn't that create at least some kind of question as to, whether this was information that was confidential?
I don't think so, because I don't think that there's any basis to assume that they went into the account to discover the names of these people.
So what's your theory as to why they went in?
At most, if it was deliberate and not inadvertent, perhaps they went into the account to get address information. And the address information, I think it's conceded, once you have the names, and since they had the names and they knew who the...
Well, how do we know why they went in? Why isn't it a question of fact? Why isn't what you're saying total speculation?
No, I don't think it matters why they went in. I think that you have to look at the kind of remedies that are being...
Well, but to start with the basic, I mean, if they went in, and they went in for an improper purpose, even if it's only to check the zip codes, it's still improper to use somebody else's account to check zip codes. That's a breach of fiduciary duty, isn't it? You may not say, you're not going to get very big damages, but it is a breach of fiduciary duty.
Well, I think whether it's a breach of fiduciary duty depends upon when it takes place. If it had taken place during their employment by Ashland, then certainly, yes, it would have been a breach of fiduciary duty. But my understanding is that the fiduciary duties owed by an employee terminate with the termination of employment.
So they were perfectly free, when they terminate the employment, you're perfectly free to go into your employer's accounts and use the information?
I don't know that they
Even if it's assuming it's not a trade secret?
I don't know that they were perfectly free to do this. But I don't believe that this Court can hold for policy reasons that where the information is as trivial in value as the addresses, as opposed to, and I think this is clearly distinguishable from a case where the terminated or the leaving employee doesn't really know the customer.
Yeah, but nobody disagrees that there's no summary judgment on breach of fiduciary, right?
No, I disagree. I think that
yeah, but the courts don't.
You would go further than the dissent below was prepared to go.
Yes.
They would have the dissenters below would have upheld the breach of fiduciary duty claims. You're not even giving the plaintiff that.
No, I'm not, Judge. Okay. I think if you look at what has been alleged here in terms of breach of fiduciary duty, what we're really talking about are some scattered, disjointed allegations, several of which are not even supported by competent evidence.
So how would you frame that if we were to write an opinion in your favor such that it would apply in the State of New York?
With regard to breach of fiduciary duty?
Right.
I would say, first of all, that the plaintiff has failed to come forward with evidence to establish any sort of causal relationship, for example, between this unauthorized trip to Peoria.
No. You were saying it's scattered. It's. I guess you want to say it's inconsequential.
It's inconsequential, and I think it's insufficient to make out the plaintiff's burden here to establish a.
Where do you draw the line?
Between.
Where you can take information that belongs to somebody else and say this does not amount to a breach of fiduciary duty because it's minimal or de minimis or scattered or.
There was no information that was taken during employment. The allegation here is that after Mr. Jones and Mr. Obakowski left the employ of Ashland and started a competing business, that they somehow gained access to Ashland's Federal Express account and through that account sent out these solicitations.
Right. And you say that's okay?
I'm saying certainly it's not a breach of fiduciary duty, and I'm saying it also does not support the kind of remedies that are available in an unfair competition claim. If this Court is concerned
Actually, it's on the record. I mean, it's not, since they denied doing it at all. We don't know whether they did before or after they departed, right?
Well, the allegation is that they did it after they departed. The allegation is that they did it sometime in October, and that indeed is what the evidence submitted here are Federal Express labels, which all I think bear a date in October. Some of them may even be November. They left Ashland in the middle of August. So there's no question that whatever occurred here took place long
Well, of course, I suppose you could say that when they left, they took with them the Federal Express account number and used it a couple of months later. Is that a breach of fiduciary duty?
If they had done that intentionally, and there's certainly no allegation that they did, and there's no allegation that they did that much even.
Okay, I'm sorry, we've used up too much of your time. What about the other causes of action?
Well, I think that the cause of action here that seeks to construe this confidentiality agreement as a restrictive covenant offends the rule of strict scrutiny that applies to such agreements. It offends the rule enunciated by this Court that these agreements have to be subject to reasonable restrictions.
You're basically saying that there's nothing that supports an injunction against customer solicitation.
Yes, on these facts.
And I mean, I guess I'm kind of impressed by your first point, which is that that agreement doesn't say anything about customers, so I don't care whether it's valid or invalid, or long or short.
Well, I think that the fact that it doesn't say anything about customers prevents any sort of claim that this can be construed as a non-solicitation agreement.
Okay. Assume absent an agreement, why is it okay for you to solicit to the former customers?
Well, they're not trade secrets, first of all, and it's well settled that to the extent a former employee is able to recall through casual recollection the customers or clients with whom he dealt, he can solicit them in a new business or for a new employer. And I don't think that there's any dispute here that these names were recalled through casual recollection, that Mr. Jones had daily contact with them.
You'll have rebuttal. Let's
thank
have
you.
your adversary.
Good afternoon, and thank you.
Counsel, is this confidential information?
It's absolutely confidential, Your Honor.
Tell us why.
And I'll walk the Court through it.
Yes, please.
Actually, if you look at what was going on, this was theft of confidential information, and this actually is well-settled case law in New York. If you look at Town and Country from this Court said where you can't assemble a list from publicly available sources, that is trade secret confidential information. And in that court, in that case, the Court upheld an injunction, a permanent injunction, where there was no agreement whatsoever.
What about Leo Silfen? I mean, they said it's okay to use the customers.
Leo Silfen, I'm sorry, Your Honor, I didn't mean to interrupt. Leo Silfen's different. In Leo Silfen, he went to, I think the defendant is Cream. He went and he showed the Court, I went to a commercial mailing list house. I think that's the words the Court uses. I didn't, and I think it's in the decision. I didn't use any of their confidential information. Here is a commercial list that I used. And that's where the Court goes, if there's a studied copying of physical appropriation, that's wrong. But Silfen walked in with a commercial list. And then the other...
Silfen also makes a big deal about how this customer list, although extensive, wasn't that hard to compile, would have been easy to duplicate. And I got the impression they were saying it's not a trade secret. Are you saying this list of 44 is a trade secret?
The list, our entire customer list, absolutely is a trade secret, and it's throughout the record. And Mr. Hickox testified.
Why wouldn't you put that in your agreements then?
We did. If you read the agreement, and I don't have the record site.
Not all customer lists are trade secrets.
Not all customer lists are. And the cases, including Reed Roberts, is the same kind of case. Reed Roberts, the Court says, in this particular instance, and Reed Roberts, the defendant went to Dun & Bradstreet and copied down the $1 million list or something.
Well, how do we know here how much time and effort, proprietary interests, all the types of things that you would look at to determine a trade secret?
In this case, Mr. Hickox testified at his deposition and submitted affidavits that it is impossible to compile this type of list. And he used the phrase, and it's in the record, the know-how is to figure out where these clients are and who they're referring business to. He said you could download every name in the world and you'd still never be able to figure it out. And I remember reading someplace in the papers, the defendant said, well, we could call up Smith Barney and get to these people. But you couldn't. These are very specific brokers and referrers of business.
Is it true that they're all people that Jones knew before he left?
That's true. I don't think all of them, some of them, because I think in the list of 44, there are. But the cases, Reed, Roberts, Silfen, and Town and Country, and actually you read BDO Seidman, they talk about the famous Blake article. If an employer empowers an employee and introduces him to people, that's the employer. The employee can't walk out with the list if it can't be assembled. And here's the more interesting part is everyone focuses on Jones.
Is it essentially your case that they actually took or appropriated a written list, either electronically or on paper? I mean, if he just happened to have a good memory and remembered 44 names, is it okay for him to call them?
I don't think so, and I don't think the cases say that, because the cases say, Silfen says, if you have a written agreement, casual memory is irrelevant, and that's what the First Department held. Our case is that they took the list both before, and then they went and I don't think it was, they hacked into our computer system.
Okay, suppose the facts are that he knew a lot of these people, that when he sat down and worked on it, he came up with about 32 of the 44. He couldn't remember their addresses. He didn't want to go to the trouble of finding out. He says, I'll do it the easy way. I'll hack into my former employer's account. Bad thing. Illegal. Is that theft of a trade secret?
Absolutely. Because
Where's the trade secret?
The trade secret is our client list. And every case this Court has decided before that I've discussed, Reed, Roberts, Silfen, BDO, and Town and Country, all talk about when an employer puts together a list of names that are not publicly available.
Don't they talk a lot about how much effort you have to put into compiling the list?
They do.
How much? And where's the record on all the effort you put in to compile this list?
In his deposition, Mr. Hickok started to talk about looking at Nick Jones' T&E records, that he sent him down 6 times to Florida in a year. I mean, I'll admit that in the record it doesn't say we spent $1 million since 1974. But is that going to keep him?
That is the kind of record you had in Town and Country, isn't it?
I don't think Town and Country was that explicit. I may be wrong.
Some of the cases, there's actual dollar amounts for what was invested in order to develop the client base.
In some of the cases there were. But I asked this Court, given all that we put forward, is that enough to deny us the chance to get to a trial? What I heard from my adversary sounded more like a summation to a jury than an appellate argument. These are all issues of fact. Maybe there's and here's an interesting point. We said that we expended serious time and money over the years. It was never contributed once. They submitted 5 affidavits. Not one affidavit said, you didn't spend any money, I spent all the money. Nobody ever challenged it. So maybe in this particular case we didn't put in $1 million. But on the record that
is there any sum, or you just said a lot of money?
We said significant time and expense developing.
And significant was not further defined.
It was not further defined. But I don't think in this case it's fatal, only because it was accepted. It went unchallenged. And 2 IAS judges in the First Department, it went unchallenged. And I can't believe that if that's what it is, that denies us the right to a trial, because we came forward and we showed it wasn't casual memory, which of course is an issue of fact anyway. We showed websites didn't have addresses. Some people weren't listed. We showed they hacked into our account and they took the wrong address. I think it's more than sufficient to get to a trial, and I think the injunctions that were handed out in Ashland 1 and Ashland 2 were warranted. I can't see where we failed in any respect. And there's one point that's just been eaten at me. The dissent went to, I think, more than engaged in fact-finding. They went and they started to manufacture facts. And this has got to me. At one point they say that they asked Mr. Hickox if use of they were talking about this letter from Nick Jones where he apologized for using the FedEx account. And the dissent went in bracketed languages and said, well, Ashland's use of the FedEx account was not a consequence to Mr. Hickox. That's not what he was talking about. I think it's at 96 of the record. He was saying whether Mr. Jones apologized for the letter, that might have been of no consequence for him using it. And I think what has happened here is that we've lost track of it. This was a motion for summary judgment. And we came forward with everything you're supposed to come forward with. We showed there's an agreement. The agreement says technical, know-how, secrets. It does say client lists on it. You can't take any of it. That's the property of an employer. And employers shouldn't be vilified. Mr. Jones and Mr. Obachowski, who only worked for Ashland, Obachowski worked for 1 year prior to starting to set up this other business. He's really, I mean, that's the flip side of it. He walks in, and all of a sudden he gets a client list that it took Ashland 30 years to put together after being there for 12 months. That can't be right. And in this respect, I think all the cases are there for this court to cite to the previous precedent, especially Town and Country, to say where a list like this can't be compiled, it is a trade secret.
How do you address the dissent's argument that there's no time or geography attached to this, so that essentially if you win, these two cannot practice their profession in the state of New York for the rest of their lives?
That's not, because it's not accurate. They went out, they can
What's the
practice.
time and what's the geography?
With respect to a confidentiality clause, I don't believe it has to be limited, because when does something, one of the cases we cited says there is a temporal restriction on time, and that's when it's no longer confidential.
Yeah, well, I'm saying that the dissent says this. Are you saying that because it's not a non-compete clause, it doesn't need that?
That's correct.
And isn't the refutation of that then that it's a confidentiality agreement as long as I work for you, but once I'm out of there, I don't, it's no longer a confidentiality agreement I'm bound by. I don't work for you anymore.
Well, that's why, no, because the confidentiality agreement says we're going to expose you to all of our confidential information and sources. The things, take Obachowski, the things that took us 30 years to acquire, we're going to expose it to you like that. When you leave...
Yeah, I think anyone would agree if they had stolen the secret formula for for eternal life, which you had in your safe, and they'd broken into the safe and taken it with them, you'd get a permanent injunction. It's not a question they get to use it after a few years. But I don't think you're really claiming you have anything like that. I mean, are you saying that the names, that these 44 names or any other names of people they may have contacted, they have to leave alone forever because they stole the names from you?
Yes. Because you can't find those names anyplace.
You have confidentiality agreements all over the place. Let's assume you've got one at a car dealership. The guy leaves his job as a car salesman, he goes across the street and he starts selling cars to somebody else. He can't call anybody that he talked to on the other side of the street.
The clients he brought with him? Yes, he can. The clients that the car dealership, for instance, said, we paid for the advertising, if you signed a confidentiality agreement, I would say that's binding.
It's kind of a right to restrain a trade. I mean, somebody says, I want to buy a Ford. Says, I can't sell you a Ford because I tried to sell you a Chevy.
But there's a difference. In a confidentiality, in that case, the guy came to him. This is solicitation based on a confidential list.
So if a lawyer leaves his firm, he can't call any of his old clients unless he brought them with him to the previous firm?
I think the lawyer, well, I know where you're getting. I think the lawyer cases are a little different because of the ethical rules. But and so that's why I think you take them out of there, because I think that's what they talk about in Seidman was an accountant. But in this kind of case, in every case this Court has decided, it recognizes that clients that you can't find, that I think the phrase the Court uses are not publicly available, are trade secret protection.
What's your best case on that?
That would be Town and Country. They cite the Blake Law Review and BDO Seidman. They also say that in Reed Roberts, and I believe it's also said in Silfen. They balance it back. Reed Roberts and Silfen are very fact-oriented. And I think this case lines up with Town and Country and lines up with the examples, though they didn't hold in our way for Reed Roberts and Silfen, because those facts didn't line up like that. Those were publicly available. You can't find this list anyplace. And when does something become non-confidential? When it does. That's the time limitation on it. Or else how would you protect the Coke secret? Or how would you protect the elixir for life? Or how would you protect these names?
No, I understand that, but when you get into names, it gets difficult because presumably you bring your friends in. Now, you'd say, well, that's not confidential because they're your friends. They're your relatives. Now, you work there for a period of time. put the 17-month-old guy over there. And because of your friends, you got others, and because of them, you got others. You want to say there's a cutoff there where that tail stops. That even though your company is benefiting from those relationships, and this guy leaves, he can't take them with him.
I can see where you're going. And as for I'm not sure those facts line up here because these were all clients of the firm. Nobody brought anything to this particular firm. And just
These
to
are
get back
referral people, right?
These were people that we developed. But getting back to your original point, nobody was stopping them from earning a living. They could go out and do the same exact thing we did. Nobody stopped them. They could go out, they could spend their own money, they could try and develop a business, they could try and develop a product to compete, and then they could try and find somebody to sell it to. Instead, they just said, well, we'll take this entire list, and guess what?
That's troubling. But the flip side of it, though, is that let's assume they do that and they purely by accident trip over one of your people. Mm-hmm. And then you say, wait a minute, that's a violation of the confidentiality agreement. Well, how are we supposed to know that? That's why I think the law tries to get some definition on these. And, forget time and geography, but to say that something is confidential, or it ought to be identifiable.
Well, I think the law has said it. I don't think there's that much confusion in the law. I think this Court's been very explicit and said if it's not publicly available, if you can't find it someplace, and the employer spent time and resources, that's considered, and it's in every one of the cases.
Are you saying the cause of action for breach of fiduciary duty and the cause of action for unfair competition rise or fall together?
Well, I think there's other parts that we've been
is
focusing
it
on these
possible
lists.
for us to let one go forward but not
I don't believe
sufficient
so.
basis for the other? I know that's not your position. I'm just saying theoretically could that be done? Or do you think that in this case they both survive or they don't survive the summary judgment motion?
I think the breach of fiduciary duty absolutely, even the dissent said that survives. I think unfair competition, that survives because we haven't really addressed here today all the other set of facts about when they set the company up and how, excuse me, how all the actions they took during the 6 months to sort of cultivate their business. And I think that whole set of factors also adds to a breach of fiduciary duty and unfair competition. And it's, again, where I've touched on. This is, it's summary judgment. Okay. Thank you very much for your time.
Counsel Rebuttal.
Thank you, Judge. This issue, my understanding of the law, and I think that this Court has been clear on this, is that customers and clients, if they are not trade secrets, then a former employee can go after their business. There are no restrictions, absent a valid non-compete or non-solicitation agreement, where those customers and clients are not trade secrets. They're fair game. And I think that's exactly the situation we have here. To establish that their clients are trade secrets, Ashland would have had to come forward into this to the Court and laid out exactly the kind of expenditures that went into finding these people and the kind of efforts that went into finding them, and it did not. In fact, all of the evidence in the record.
What about that he says it was uncontested the whole way through?
What was uncontested, please?
That they spent a lot of time and effort, significant monies on it.
That
nobody challenged it, went through 2 judges, whatever. That's what he said.
Well, I don't think evidentiarily that's true. And every business, if what he means is that the business spent time and effort developing clients, sure, every service business does that. Insurance agencies, and their lists are held time and time again not to be confidential or trade secret material. Brokers do this. I mean, every landscaping services, every one of these types of businesses develops goodwill through the investment of time and money in cultivating a customer base. Yet there is no law that I know of that says that simply because of this kind of generalized investment, the employer gets a right to prohibit his employees from ever going after these people, absent the showing that there's a trade secret or absent a valid non-competition or non-solicitation.
What does Town and Country say? He relies on that a lot.
I think Town and Country has largely been eviscerated by this Court's holding in Leo Silfen Inc. versus Cream, in which it held that customers who are not trade secrets, who are casually recalled, are fair game. I don't think that, to the extent Town and Country.
There's language in there that says maybe not when there's an egregious breach of trust. Could a jury here find that your client had breached his trust?
I don't think so, Judge. There was no competition that took place during the period of employment. There was no showing of any sort of taking of property of the company or use of its resources in setting up a competing business.
If there was, you would then say that that's an issue.
Sure.
Because the taking of the labels obviously is out there. But in this day and age, computers are so accessible, and I mean, you can get so much information with a computer code, and and no one would even know it.
Well, I think we have to look at the nature of the information as well. I mean, if that kind of conduct is done to identify customers to solicit, that's one thing. If the employee doesn't have knowledge of them to begin with, but if it's done as is alleged here, if it's tangential to the main issue, which is who owns these clients, or does Ashland own these clients such that it can bar the defendants from soliciting them, then I think this kind of almost inconsequential transgression cannot be dealt with the kind of draconian remedies that we're talking about.
Okay, counsel. Thank you both.